Dear participants, dear friends, I would like to open this Global Digital Encounter number 32 with some elements of emotion. We have awaited this moment for very long. We have awaited the moment not only to have a unitary patent system and a unitary patent court, but also to be able to consider its first results and its challenges. We have awaited for this moment for some of us for more than 60 years, and this time has at last arrived. There is in Europe a jurisdiction that is a supranational one, that is able to render justice to applicants and challengers, to patent owners and to challengers in an organized supranational way. This jurisdiction, the UPC, started its operations only on June 1, 2023, and now has already a high number of cases, which showed the need for business, for society of such a jurisdiction, which shows its importance for the future of innovation, but also for the future of the European innovation. As such, this is therefore a very, very special moment for all of us. I would wish to thank, on this occasion, all those who support the Global Digital Encounters project. This is our 32nd edition, and this is long. We started practically 4 years ago for this pro bono project aiming at studying, reconstructing an IP world that prepares society for tomorrow. I would wish to thank also all those who connect from all over the world to our events, those who follow them live or later on, and above all, the very distinguished speakers and moderator we have with us today. We have an exceptional luck to have among the best experts of the topic we are considering, moderated also by one of the best experts and academics in this field. So we are super, super honored of this. And we are super honored that we can have a debate in an academic environment. I know that all our speakers today are present in their personal capacity and do not represent specifically an institution, but represent an authoritative voice, an informed voice in the international community of innovation. That's why we are so proud of this very, very long-awaited and special Global Digital Encounter. We placed it precisely in February 2024, so that we have practically an 8-month distance since the start of operations of the UPC, so that, yes, we can already have some background on what happened since June, and we can also see what challenges our system needs and will meet for sure, thanks to the energy of those who run it. I declare this 32nd digital encounter open. Wish our audience to interact with us as soon as the chat will be open. Our speakers are awaiting for your questions, for your doubts, for your request for more information. So we will hope to meet your expectations. I remind all of you that this encounter will be followed by a report and by reading material that will be accessible to all those who follow it. Thank you for your attention. And together with my co-director, Professor Manuel de Santos, we are so honored to have distinguished speakers with us and a distinguished audience. We are also very proud to have the EPO with us, as we had in the past, the UIPO and WIPO. We are super happy that, though of course it has to be in personal capacity, EPO is represented by one of its senior officials. So I wish all of you an excellent Global Digital Encounter, and we wish to leave the floor to my colleague, Javier Fernandez-Laschetti, who is the coordinator of the Global Digital Encounter, and is also very active in the field of patents, and will make a very brief introduction as well. Javier, the floor is yours.
Yes. Thank you, Laurent. Thank you very much. A very short introduction, because I think that our friends are waiting for these good and fantastic speakers and moderator. Yes, this is in a certain way it's a dream that has come true, because we have waited for a long time, at least the ones that are a bit older, you know. And but it has come, yeah, it has come to an end. It's working, and it will work perfectly. And you will see that this apart from noise and comments from coming from different places, you will see and you will discover that it's a very fascinating system to solve the conflicts at the European level. So I think we are all very happy to have this in place, and we hope to have very important and relevant jurisprudence coming from this new court. So thank you very much for joining us, and thank you for being with us. You know that you are a community, we are a community, and we hope to have your comments, your questions, etc., etc. And that's all from my side, Laurent. Emmanuel, the floor is yours. Thank you.
Thank you, Javier. Thank you to all the organizers. And indeed, so the UPC after 8 months, achievement and challenges. Well, maybe we could have said first achievement and challenges, because there will be many more certainly to come. On this roundtable, we have Rian Calden with the Court of Appeal of the UPC, Kevin Mooney, Simmons, and also has been very active with as chair of the drafting committee on rules of procedures, and Miali Fixer from the EPO, Advisor Legal Affairs. So we have 1 hour to discuss these achievement and challenges, and probably to start with this, what we were wanting to discuss in a way is looking back at the starting point, at the genesis of the Unified Patents and the UPC. What the panel, what is your perception on these first period, on these first 8 months of the UPC and the UP system? And in a way, because this has been a long-standing process coming to this point in time with the start of the UPC in June, does it in a way look like what was initially designed and anticipated, or have you seen already now new elements, new items in a way that you did not at the time anticipate? Who wants to start here?
Well, I don't mind starting, Emmanuel, if my colleagues are okay. I don't want to jump into statistics, but we've had probably, depends on where you get your statistics from, but there have been 120 cases that have been started since the 1st of June, approximately 80 infringement cases. The bulk of those have been 54 of them have been in 3 divisions, local divisions in Germany, and we can talk about that a little later. But there have been, in addition, a number of revocation actions. Essentially, most of those have been started in Paris, and there have been other procedures, provisional measures, saisies, so to speak, in a variety of divisions. So the start has been very international. And speaking for myself, I would say that there have been more cases than I hoped for and less cases than I feared for. So I'm very happy. And my own firm has been quite active. We have started 8 cases in various divisions, and I can report that the clients have been very happy. And just so I can quote from 2 publications recently by distinguished law firms, one by Herbert Smith, who said the UPC has made a roaring start, and the other one by Finnegan Henderson in the US, it says the UPC has managed to establish itself as an appealing jurisdiction. So taking a very broad view, I'm happy, and a number of other people are very happy as well.
Well, if I may, Emmanuel, maybe just to complement this first statistical overview of the initial months of the system, I think the Unitary Patent has made a very good start at the EPO as well, both in terms of uptake rates and operational efficiency. A little less than 2 weeks ago, we passed the milestone of 20,000 requests for Unitary Effect. And it is just exactly today that we passed another great milestone, namely the milestone of 20,000 UP registrations. So the event couldn't have been timed better. Last year, we saw more than 17,000 requests for Unitary Effect, which represented a higher than expected uptake of 70.5%. Now, this uptake rate indicates the percentage of all European patents published in 2023 for which Unitary Effect has been requested. So I think it's a very promising uptake. Now, compared to this impressively high number of requests, maybe you will be surprised to hear that thus far only 12, a dozen requests have been rejected, which is below 0.1% of all the requests. Most of these rejections are due to the set of claims not being identical for all the participating member states. And currently, it takes less than 10 days to process a request for Unitary Effect. And as a rule, formal deficiencies can be corrected within a 1 month time limit. Now, what do these statistics tell us? Firstly, the level of demand clearly shows that the Unitary Patent does correspond to some very essential needs of our users and has proven an attractive option for obtaining patent protection in Europe. So the system is what it has promised to be, a user-friendly and fit-for-purpose system. Secondly, the operations at the EPO run smoothly and in an expeditious manner. And last but not least, users have also demonstrated a very good understanding of the UP system, which has proven, by the way, very simple and easy to administer.
Thank you, Miele, and a very optimistic, in a way, starting point for the unitary patent, so to say, or European patent with the unitary effect. I don't know whether Rian Calden, from a sort of user perspective, here the user being the court itself, or the actor, I should say, rather, whether there's any specific general comment as to the, I know we're more addressing here the perception, but the judges may nevertheless have a perception themselves about the system. Oh, you're on mute.
There I'm going. Yes, so I think we have, like in our digital filing system, we can talk about internal and external users. Of course, I'm an internal user. So from an internal user perspective, I can say for myself and all my colleagues that we're all very enthusiastic about it being able to work in this system. I must say, it's a very enthusiastic group of people, both the judges, the legally qualified judges, the technically qualified judges, the clerks, IT people, HR, and what have you. It's a very nice, fine group to work with, and the challenges, of course, are enormous. We are really a startup. I'm also a member of the Presidium, so we've been very much involved in the last 8 months and also 6 months before that to try and set up insofar as it was not accomplished before, and to make it a very smooth start. And I think to a very large extent we've managed to do so. And that is reflected, I think, by the external user reports that we get if we go to conferences and we sit in panels like this. That overall we do get very positive feedback on the functioning of the court. In particularly, the users seem to be happy about the very practical approach taken by the judges, the efficiency, quick judgments, and also the wide case management powers of the judge rapporteur are also appreciated, because that allows an early involvement of the judge in cases and enhances efficiency. So we do, I must admit, we do have some issues with the digital filing system, but I think everybody knows that with any new digital system, it cannot be perfect from the start. And there's a lot of effort both within our court and with our provider, and the continued efforts from Kevin, I must say, in finding solutions, solving the bugs, finding workarounds, improve the system. And sometimes it requires a bit of patience and understanding. But normally we get that, I must say. So we really can't complain about this aspect as well. So yes, we are very happy. Yes.
Let me just add to that, Emmanuel, that Rian and I meet quite frequently to discuss problems, and I can endorse that the atmosphere is friendly, cooperative, and positive.
That's what we hear very often indeed, and actually what you've just been raising, Rian, on some of the issue to be fixed in a way on CMS or so hasn't been, let's say, blocker, to the extent that at least the number of cases is probably much higher than it was initially anticipated in a way. Maybe if we come to the sort of second side of this sort of first 8 months, which you raise already, Kevin, some of these statistics in relation to the number of cases, in relation to the nature of the cases. But maybe, I don't know whether we can also comment on the sort of profile of industry sectors, nationality as well, because what we can see is probably a number of different stakeholders, so to say, or litigants, smaller companies, bigger ones, pharma, non-pharma, US, European, Asian. So that's probably interesting and reflects what I think, Kevin, you were mentioning or referring to one quotation from, was it Finnegan, as looking at the UPC as a distinguished jurisdiction, but that probably means also being capable of attracting a number of different profiles.
Yes, I agree. It's very difficult to say that there's any one sector of industry that has decided to litigate in the UPC from the start, because there are a number of them. And I'm pleased to say that in addition to large companies, there are a number of SMEs that are also trying to enforce their patents as well. Yeah, so it'll be interesting possibly at the end of the year to do a full analysis of all of this. But from what I see, it's large companies, small companies across all sectors, Emmanuel.
Right. Thank you.
Yeah, maybe it's a bit too early to jump at any conclusions regarding what we see in the statistics, but what we see at the EPO confirms Mr. Mooney's observations. The unitary patent seems particularly attractive to European industry, with 2/3 of all UP requests originating from Europe. while approximately 15% comes from the US and 12% from Japan, Korea, and China. As with the UPC, all industries are represented, with medical technology, civil engineering, and transport in the lead. The uptake rate is particularly high in food chemistry, civil engineering, environmental technology, furniture, pharmaceuticals, and biotechnology. With respect to the filing strategy, 64% of UP users follow the Euro PCT route, out of which the vast majority have selected the EPO as International Searching Authority. Now, if we now focus on Europe, our final 2023 data show remarkable trends. Almost 19% of all UP owners come from Germany, 7% from France, a little bit more than 5% from Switzerland, 5% from Italy and Sweden, 4% from the UK. In terms of the profiles of UP proprietors in Europe, small and medium-sized enterprises accounted for a very large portion of UP owners in 2023, more than the same percentage for all European patent applications, with 34% of the total. Whilst research institutions are also well represented, above 7.5%. This trend is even stronger in some European countries, for instance, in the UK, Spain, and Italy. Now, maybe a few words about languages, because this is also a very interesting piece of the puzzle. Last year, almost 700 requests for compensation of the translation costs have been received at the EPO, making up slightly less than 5% of all UP requests. Now, more than 50% of these requests related to applications submitted in Italian and 15% to applications filed in Spanish. In terms of the languages of the proceedings, 3/4 of the requests have been filed in English. And when it comes to the translations of the European patent specification, 30% of the translations were received in Spanish, followed by English, 26%, and German, 21%.
Well, thank you for reporting on this side. So, I mean, from the EPO side, if we turn to the court, maybe, is there any specific comment in addition, Rian Calvin?
Well, I think it's interesting to not look just at what kind of cases, but also where the cases go. And there we see quite a bit of dominance, if I may say so, for Germany at the moment. So about 2/3 of the infringement cases have been filed in Germany. Of course, as you know, for revocation cases, there is a different regime, which is dependent on the technology of the patent. And that will also change later this year when we will have the central division in Milan as well. At the moment, most of the revocation cases are filed in Paris. 20 out of the 24 that were filed in central division. But some of those technologies will move to Munich, and Milan will get the human necessities class of patents. So we'll just have to see how that spreads out. But as far as the infringement cases are concerned, there is of course a lot of choice in where to file your cases, and we have to say that Germany is very much a country of choice so far. Maybe also because Germany has always been a country where there is a lot of patent litigation going on, whereas normally in each country you have like somewhere between 30 and 60 cases a year. In Germany, they have like thousands of patent cases every year. So maybe that's also a reflection of what the Germans normally do. As to languages, there's another interesting situation, because I think many had thought from the outset that this was very much going to be an English dominated court, even though the UK would not participate. But we still see now that German is dominating, but it is getting less. So at the moment, 47% of the cases are in German, 43% are in English, so it comes close, and 10% in other languages, mainly German, Dutch and Italian. So we see a slow increase of English instead of German. And one of the aspects that may be relevant here is that in the very beginning, of course, every country had to notify which languages would be allowed in its local divisions. And to be honest, Germany, as well as France and Italy, I must add, but particularly Germany is quite relevant here, was quite late, not to say waiting until the very last moment, with notifying that English would be allowed as a language of choice in the local divisions. So therefore, all of the first cases, so let's say those filed in the first weeks, they're all in German, because since that notification didn't come, the party started drafting this in German, and didn't want to translate, of course, last moment. So I think it's it remains to be seen how this further develops.
Would you say that English would facilitate the work of the judges in a way as a common denominator between the various European judges sitting with the UPC?
Well, I mean, I think you have to be realistic in the application process for the judges. So in the recruitment phase, it has been particularly looked at whether the judges would be sufficiently proficient in English. And not all judges, and so all judges are sufficiently proficient in English. Everybody can rest assured that a case dealt in English will be understood by all of the judges. That is not the same for German. There's still quite a number of judges that do speak English and French, for instance, or English and Italian, but they do not necessarily also speak German. So from an organizational point of view, the pool of judges that is available to deal with the cases as a third judge in local divisions is, of course, smaller if you would only select on the basis of language. And that, of course, in the end, that cannot be the only factor, because that would rule out a number of judges. So in the end, I think, the advantage of having German to some, in the end gets a disadvantage that the judges will need translation, because at least one or maybe two, because the technical judges also don't always speak German, need translations. And I'm not quite sure whether the parties, when making a strategic decision as to language, take into account that some of the judges will read from translations that they will prepare themselves. And that may not be ideal, because normally you would like to, your lawyers tend to be quite careful in how to draft their statements. And you don't want to rely on translations that you have no control of. And in addition to that, of course, there's also the risk of a language change. So that also has to be taken into account. Already 11 requests to a language change have been filed. And in some circumstances, this has been allowed. As a very recent development, I can tell you that 6 cases, but they were sort of, in a cluster of cases, went up to the Court of Appeal on the language issue where a change of language was not ordered. And that case actually settled was subject to approval by the clients, but still it got settled in the room, so to say. And the basis of that settlement was actually quite interesting because at that hearing, we had simultaneous translation provided for the judges. And one of the parties had requested that that the representative who was not a native speaker, whether he could speak English as well. And that was allowed by the court. And then it turned out we had, of course, arranged for simultaneous translation. Nobody used translation. So as long as everybody would be able to speak in its own language, everybody was happy to listen to that language without translation. And that basically was the basis for the settlement. So, so the settlement was the official language doesn't change. Each party uploads in addition a working version translation of its statements. And all representatives get to speak their own language in the courtroom.
You would have in one same hearing different languages being discussed or used with the judge, despite obviously you have one single language for the procedure itself.
Yes, but so actually, if you were in my courtroom, it was a quite interesting hearing because some spoke German, others spoke English, and also, questions in English, answers in German. It all, was one bilingual situation, but everybody was happy because speaking and understanding is two quite different things. So yeah, that ended up being quite a practical solution to this, which may, maybe an inspiration for settlements on language in the future as well. Because the UPC agreement not only allows for an application to change the language, but also the parties may agree on the change of language together with the judge rapporteur. So who knows? This will be one of the ways to go.
Emmanuel, let me just say that I agree entirely with Rianne. The greater the flexibility on languages, the better. People shouldn't be forced to fight cases at a disadvantage. But just some comfort, Rianne. As I've already said, statistics depend upon where you get them from. But from my own firm yesterday, I was told now that English has overtaken German.
Oh, really? Okay. Well,
okay.
So are you showing this as a sort of trend whereby English Rian was referring to 47% of the cases in German, but maybe next year, same time, same day in the year, we'll see a different position.
Well, I think for all the reasons that Rianne has given, that all of the divisions have offered English as an alternative. The only regional division works in English. 80+% of the patents were prosecuted in English. For all of those reasons, I think it's inevitable that English will eventually dominate. But that's not to say that the flexibility that Rianne's referred to is not a good thing.
Well, I think also, English is not a native language to anybody in this court.
So far.
Well, up to now, no country has English as its official language. And there may be some, native speakers around, that, or bilingual. But normally speaking, it's everybody's second language. And that makes it even fairer. It's more balanced out. If everybody, gets to speak foreign language to a certain extent. And I'm not saying German or French should not be used. I'm not saying that at all. There are certain circumstances, of course, where it's more appropriate to use French, or German. But of course, the language of the patent is a very strong denominator for the language of the proceedings. And as Kevin said, 80% of all the patents is in English. So it's only logical, I think, that in the end, the majority at least will be English. But there will certainly always be room for the other languages to be used in our court as well.
Well, thank you for sharing on languages, which is obviously a key element when filing a claim, when, as you were saying, being in courts, how to operate, and for sharing obviously this reference of your last hearing in earlier this week, if I understand correctly. One other topic, I don't know whether it's the right time to try to cover that, is about the rules of procedure, the backbone in a way of the system, and to see how they've been applied in practice so far. And if you want to share some of the example of situation where you've seen good or more difficult positions where, and maybe also you were referring to the key role of the judge rapporteur, and probably he or she is key in the way to enforce a number of the rules of procedures. I don't know who wants to take here the start of the conversation on the rules of procedures.
I don't know. Is it helpful for people to understand how the rules of procedure came into force? Very briefly.
I think it is, yeah.
Okay, well, I'll be as brief as I can. The agreement to create the court was signed in February 2013. And the agreement in many places says this or that will be done in accordance with the rules of procedure. But in autumn 2012, the previous year, there were no rules of procedure. And industry was saying, how can we possibly advise our governments to sign this agreement with all of these references to rules of procedure when we don't know what they are? So I travelled to Brussels for a regular meeting talking about the drafting of the agreement. And I got into my hotel at about 10 o'clock at night. And I got a mobile phone call from one Sir Robin Jacob, who said that I'd had a meeting yesterday with Dr. Frolinger, who was leading for the commission, and we agreed that you should chair the committee. And I said, well, thank you. Thank you. I said, at least can I choose my own members? And he said, yes, of course you can. So I chose 6 people who I knew were very competent and very authoritative. They were judges and lawyers from different European countries, and that's how the Rules of Procedure Committee was created. So we have an expression in English, Korean volunteer. So I was a Korean volunteer. And I'm not ashamed to say that the appointment of the committee lacked a lot of constitutional legitimacy, but there we are. That's how it came about. And we had meetings over 4 years. And the final draft was published in 2016. So we met for 4 years. And the rules of procedure were finally approved in July of 2022. I think Rian has got much more to say on how the rules are being applied, though.
Well, I must say one of the challenges of being a UPC judge is the new set of rules. Of course, they're entirely new. So we have no case law to rely on, except for European law insofar as it's applicable to us. There are no official travaux préparatoires. We have a limited drafting history. So it's up to us to interpret the rules, but basically without any sort of reference to work from. And the only references we could have, of course, is national legislation. But the interesting thing about the rules of procedure, of course, is that it's a complete mixture of different legal systems. because Kevin chose lawyers and judges from different legal backgrounds. So we have common law aspects, we have German law aspects, we have Dutch law aspects, we have all sorts of things. So there's also no one national jurisdiction to go back to. And then, of course, all the judges that have to apply these rules, they read them with their own sort of legal background and their national cultural backgrounds. And, the funny thing is sometimes you really think you understand what a rule says. And then your colleague has exact same feeling with its own cultural background, but we still come to different readings. So that's quite interesting process. So you can imagine that every case that comes up to us, and so far we primarily deal with procedural cases. So every case that comes to us is, poses at least one question, but very often even more, on how these rules are to be interpreted. There are criteria set forth in the rules that have not been sort of elaborated on. So, as an example, service of statements, the first service of statement of claim, of course, the most important one. Do you do this without exhibits? Do you do it with exhibits? There's huge differences in approaches. I mean, in Germany, it's the court who's responsible. In the Netherlands, for instance, it's the parties. So how do you deal with those questions? Second example, for instance, is the access to case files. That case still has to be heard. So I can't say anything about this. But it brought about other interesting questions, like, does an applicant need to be represented by a registered representative? And the Court of Appeal has looked at the rules and has come to the conclusion that the rules provide yes. There's no policy decision behind this. I mean, the Court of Appeal just looks at the rules as a system, looks at the agreement, and has come to the conclusion that this must have been the intention. Interventions, for instance, we had an intervention in that case. What is legal interest in the result of an action? Nobody can tell. So in that case, we looked at European law, at the law, case law of the Court of Justice. So that's just a few examples of a few cases which make clear that really everything has to be developed, but that makes it so interesting.
Thank you so much. You say in a way there's no travaux préparatoires. We know that there have been nevertheless a number of different versions.
Yes, I know, but only from a certain moment, only once the public consultation came in.
Yeah, in 3 years. And so would that be, to some extent, part of what you can refer to as travaux préparatoires, which is not the proper travaux préparatoires, but nevertheless, the changes and amendment that have been made in the latest version, would that be to the court as well, an element of reference to sometimes do the construction and interpretation of the rules?
Well, I think in some instances where a new draft was presented, it has been sort of clarified by the committee why certain amendments were introduced. That, of course, gives a clarification by the drafters. Certainly there will be an element to look at, sure.
Speaking of travaux préparatoires, maybe I can announce here that the EPO plans to go public with the travaux préparatoires relating to the unitary patent on the first anniversary of the system. So it will be published on our website, but that will be restricted to the unitary patent.
Very interesting. I mean, in line with the transparency of the EPO in a way.
Well, yeah, of course.
The access of the fund. I mean, yeah. Talking about the EPO, I think one of the points we wanted to briefly discuss as well is the relation between the UPC and the EPO, and what has been done. To what extent there might be also improvements, And here I think that we have a few elements that you wanted maybe to share on the way the CMS is configured to update the EPO, this sort of element which shows the sort of interaction between the two institutions.
No, you carry on.
No, go ahead. I mean,
no, it's true that all major stages in the major proceedings before the UPC are automatically reported to the EPO via these magical things called APIs. So whenever, for example, an infringement case is started, whenever it is decided and the decision in that particular case, that is reported by API to the EPO, and the same for revocation actions, for applications to amend the patent, and many other procedures as well. So there is an extensive system of maintaining up-to-date information for the EPO electronically from the UPC.
And I can only confirm that this data exchange works well, without any major hiccups. So, and this is, by the way, based also on an agreement on cooperation between the UPC and the EPO that was concluded in November 2022. And it covers, among other things, the electronic exchange of registered information and official communications, as well as training of judges and candidate judges. And this agreement has recently been amended to provide for an IT-related dialogue between the two institutions, and also complemented by a specific memorandum of understanding on the training of judges. Now, maybe on a related note, I should perhaps also mention that under a recent EPO notice, which was published November last year, the office will accelerate its processing of parallel opposition proceedings if it is informed through these data exchanges by the UPC that an infringement or revocation action relating to a European patent or a unitary patent has been instituted before the court. So this can have a procedural impact as well. And maybe last but not least, I should mention that one specific relationship between the court and the EPO has not yet been tested, because so far no action against any decision taken by the EPO in UP procedures has been brought before the UPC. So for the time being, we are not yet in a position to address this aspect.
Thank you. And I presume on this one, in the same way that when there are parallel proceedings before the EPO and national courts, obviously the usual question is whether national courts would stay proceedings, waiting the result of the EPO proceedings. We probably have the same questions with the UPC. I don't know whether we have any comments to be made on this one or not.
Well, it's a general comment. There's a general discretion for the UPC to stay proceedings if it is satisfied that an opposition may be expected to be heard rapidly. And that's the key word, rapidly. And there are a couple of cases that have looked at this, and I suspect that one or two of them may be on their way to Rian. I don't know. What on earth does rapidly mean? Well, the only thing that's come out of the cases so far, I think, is that the UPC court must be able to see a definite date when the parallel opposition decision will be given. But how far in the future that is remains an open question. I don't know whether you're able to comment, Rian, on that.
No, I think I shouldn't.
Okay.
Point.
We'll wait for the next cases.
Okay.
Okay, well, thank you for your comment on these here. I would say another key features with the UPC is the role of the technically qualified judges. And I think probably I don't know whether there's any comment that we want to share here with the experience of and the dialogue between legal and technically qualified judges. Whether it's you, Rian, whether anyone else.
Well, I can say something about this. As everybody knows, the legal systems in Europe, although it's always referred to as the continental legal system, is not quite the same everywhere. And especially in patent cases, you see a whole lot of different approaches. So in some countries, there is a bifurcated system, like in Austria and Germany, where patent validity is dealt with by one court and infringement by another court. And there you already see that in the infringement cases are usually dealt with by legally judges, and the validity cases by a combination of legally qualified and technically qualified judges. But there's also systems where it's not bifurcated, like in Sweden and in Switzerland, where technically qualified judges are part of the panel. And in the Netherlands, for instance, we don't have technically qualified judges, but there is the possibility to have a deputy judge. And we have quite a few deputy judges. It's mainly people working in the National Patent Office that now and then sit with us as a judge. They need to be legally qualified, but they then bring their technical knowledge. And I think on the whole, I think it was a very good choice to have technically qualified judges added to the panels. Not necessarily in infringement cases all the time, but there's the possibility when it gets complicated, and especially in validity cases, sometimes it's really helpful, to have a view from somebody, at least to help you understand the technique, to help you understand the arguments that are brought by both parties. And I think it's much better to have that than to refer to an external expert that you really cannot have, communication with, who is really external to you. And it's also not part of the dialogue with the parties. And I think that's very important, that we don't get any information that the parties are not aware of. So I think to have them included in the panel and taking part of all the deliberations is a very good solution. And so far, I've been told where technical aspects were relevant, there is a very fruitful dialogue between legally qualified judges and technically qualified judges. It's certainly not the case that now all of a sudden the legally qualified judges stop thinking about technical things because we have technical judges. I mean, that's certainly not the case. The legally qualified judges are all very much used to, going into the technical aspects themselves, and they will continue to do so. It's just that they bring more technical background with them. So I think experience has been quite good so far. Very good, yeah.
And we know.
Can I just add one thing, Emmanuel, very, very, very briefly? When the training of the UPC judges was started at the beginning of 2023, the principle was adopted that legally qualified and technically qualified judges should all be trained together in the same sessions, so that there shouldn't be any kind of discrimination between them as to who dealt with what.
Well, and it's good you raised this, because we were in the preparation, we were discussing the training of the judges, and that's certainly one of the key message, because technically qualified judges in a way are judges. I say that because it's a question, but because we heard in the past, well, will they be different? Yeah, they are different in nature, different background, but once they are appointed as judge on the panel, the TQJ is a full judge.
Yes.
The technically qualified judge, well, it's for you to say, but will not decide only on the technical aspect of things, but will take part in the overall discussion. Is that correct, Rian?
Yes, that's true. Yeah, and of course, everybody brings his expertise in that respect. But certainly, I mean, it's one panel that consists of, you know, how many judges, between 3 and 5, and as much as the legally qualified judges are trying to understand all the technical aspects and form their own opinion on this, the same goes for legal aspects, where the technically qualified judges are also quite familiar with, you know, at any rate, with the validity ones they're already familiar with, but the infringement and the procedure ones they're very interested in, and they will certainly try and you know get their finger behind, you know, what there is to understand and form their opinion as well. So yeah, it's a common effort in a panel to come to a final decision. Absolutely.
Do we have a sense, because we were talking about statistics earlier, as to how many, in terms of proportion, concerning infringement cases, how many cases, infringement cases, we have technically qualified judges who have been appointed?
I don't have the exact number, but I think in the majority, we have technically qualified judges. Yes. Yes, and also I think so we have 89 infringement cases at the last figure I got,
yeah,
in which 53 there was no counterclaim, and in 36 there was a counterclaim for revocation. So that already tells you that at least you know, in quite a lot of cases there were counterclaims. So that also speaks in favor of having a technical judge in the infringement case. And then I also know of cases where there was no counterclaim and still, you know, the technical issues called for a technical judge to be added to the panel as well. Yeah.
Right. Okay. Well, thank you. I know we're reaching slowly the end of the session. Obviously, we can take all question on the chat. I've seen one or two which are probably more. One is directed to you and your lecturer, Rian Calden, and maybe it can be answered separately. I don't know whether there are any other point that we want to more specifically address here. We've covered a number of different topics. Obviously, it's only 8 months following the beginning of the UPC, so it's certainly there will, as I was saying at the beginning, there will certainly be much more in terms of achievement and challenges with the UPC. We've seen only the first step with the first decision from the Court of Appeal. There will certainly be much more to come. I'm just looking at the chat here. We had one which was about we've covered that indirectly, about the divisions, regional but local divisions beside the German ones, and probably you collectively answered this, which was about where, in terms of local and regional divisions outside Germany, and I think you said to some extent we've seen a variety of different locations, whether that's the Nordics, whether that's we've seen cases in Austria, in Italy, in France. I don't know whether from a statistic perspective you want to have an additional and final comment on this.
No, it's basically it's in the Nordic, Milan, The Hague, Brussels, Helsinki, Austria, and Paris. So
yeah, just to emphasize that it's international, it's not all in Germany.
Yes, exactly. Yeah.
Yeah. And we've one last questions about the number of cases of infringement cases which had a counterclaim. Was it 36 you mentioned earlier?
Yes, that's what I was told. Yes.
Yeah, that's okay. So you can see in the chat. So we heard from Rian Calden 36 on these. Okay. Okay, I think we're on time. We were meant to close at 4:02. It's already 4:01, 1 minute earlier. I should thank the panel, Rian Calden, Kevin Mooney, Mieli Fixer, for sharing with us. And I'll pass on to our GDE patrons. Manuel de Sanchez, take the floor. Thank you.
Thanks very much, Dan Manuel. Having you as a moderator of this 30-second encounter has been a pleasure and an honor for all of us. So there, Ryan, there, Kevin, and there, Michal, we are also so grateful to you. We welcome you 4 to the Encounters family. Encounters family, by the way, that it's a family that, thanks to you, is composed already by more than 100 of remarkable scholars and professionals. You know? So what an exciting topic today, I should say, what an exciting topic for everybody, and what an emotional topic for Europeans. You know? We all are fully aware that this is the first time in the history of law, I should say, that an international court jumps massively into private law. And I always have understood this as a terrific sign, not only for the small world of patents, but there are many other professionals and academics looking at what you are doing, because this could be the unicorn, which will bring us later on in other topics like labor law, consumer contracts, insurance, torts, or even selling of goods to a direction similar to what you are doing. No? And this is extraordinary. We all are fully aware that this is also the first time in the history of patent law where a unitary patent where 16 member states are involved jumps massively also into the scene, yeah, and everything is complex, yeah, and everything is complex under the enhancing cooperation procedure. I guess we also are fully aware that it is the first time in the history of law where legal trained and technical trained judges come together and cooperate together in order to render better informed judgments in an international court. There were experiences in some countries like Germany, but not in an international court. So we are talking all in all of a dream of more than 60 years. You remember, Kevin, that the first European Patent Convention draft comes from 1962. Yeah?
Oh, yes.
So more than 60 years. During these long decades, each one of us, including many that regrettably are not here with us anymore, have expressed our views, and always, and obviously not always in the same direction. Yeah, it is known, for instance, that I have always pleaded for a court within the framework of the Court of Justice of the European Union, and a system fully governed by EU law for many years. But this time is gone. Today, we have a unified patent court serving to both classic European patents and European patents with unitary effect. We have today an international agreement very solid and coherent. And most of all, I should say, we have a complete set of procedural rules that cover completely the UPC process, not leaving any room to the application of national laws. And we have seen today in this encounter that the system has started working quite smoothly. And these are very good news, actually. So time now is for evaluating the system, for supporting the system, and for identifying critically the challenges and the possible improvements. So as a conclusion, I should say that we all knew that the system is complex. We all knew that this is a new venture, and we all have to congratulate ourselves that it has started working so decently, I should say, yeah. I have the feeling, and I guess you also have the feeling, Emmanuel, that we could have spent many hours reflecting on many other issues. Yeah? But believe me, you will be surprised when reading the report how many questions you have brought on the table in just 1 hour. It's amazing. Yeah. The purpose of this exercise, remember, was not in any way to exhaust the matter. Be sure, all of you, that we will have in the future many other encounters where we will have the opportunity to dig on other UPC and unitary patent related matters. And if it is necessary, with a much more critical hat, let's say. But today we just wanted to highlight the first impressions from the very protagonist And my feeling is that you have done it very well. So it is a must to recall also here that you will have a report, that the report will be drafted this time by Raúl Ruiz Rodriguez and by Javier López Guzmán. So thanks very much, Raúl and Javier. And many thanks also to all those who have attended the encounter today. I always try to express that we are very grateful to your fidelity towards the encounters, that we do appreciate very much whatever advice, whatever criticism, and whatever suggestions you could provide to us in order to improve the encounters. And I also like to thank to all those hundreds and hundreds who will listen later on the recorded copy on this encounter in the following weeks and months, and that will discuss privately in conferences, in social networks, the contents of the encounter. Because we are convinced that all these 32 encounters that have taken place already constitute indeed a very valuable legacy for the future. A common legacy that belongs to all of us, a common legacy that belongs to the whole intellectual property community. Yeah? So take care. Join us in the next encounter, the 33rd. The next encounter will take place on the 21st of March, that's in 1 month of 2024. And we will discuss another very, very hot and exciting topic, certainly. Yeah? The title is Eastern Asia, the new paradise for patenting. We will run in the encounter at 9 o'clock in the morning in order to get as much as possible our Asian followers. And so as always, we will prepare the materials for you, references for you. We will provide for you splendid speakers. So thank you very much for being with us today. Enjoy the rest of the day. Please, greetings to you and to all your families. Bye-bye. Thank you. Bye-bye.
Thank you, Manuel.
Thank you.
Thank you.